Good morning and welcome to the Florida Supreme Court. Our first case today is Mosley versus State of Florida, number 2023-1091.
Good morning, Your Honor. My name is George Burden. I'm here on behalf of John Mosley Jr. Mr. Mosley was convicted of 2 counts of first-degree murder. The jury recommended life for one of the victims and by an 8-4 vote death for the second victim. This is one of those Ring versus Arizona HURST cases where it was after Ring, so he was in that window, so he got HURST Resentencing after 2015. He went through that process, and because of a Ferretta violation during the Spencer hearing, this court reversed his death sentence for that purpose. We're here today to discuss 2 issues. The first issue has to do with...
Do either of those issues have anything to do with the Spencer hearing or the remand?
None whatsoever, Your Honor.
Okay.
Absolutely none
Why
whatsoever.
isn't that a problem?
Well, because this court has the power and should exercise its power to do justice in this case, and it's laid out in the brief and with the first issue that, and this is something that's coming more and more common, where we have verdicts now from the jury and they found no mitigating evidence whatsoever.
Well, what makes you think we weren't aware of that the last time we were here?
I did not do the initial brief in this case.
All right,
This was a
but
transfer
you have access to what we wrote last year, presumably.
Oh,
right?
yes, of course.
So what makes you think we weren't aware of the issues you're presenting now?
It wasn't raised in the initial brief that was done.
Isn't that a problem for you if they weren't raised?
Well, of course. The learned Attorney General correctly argued that it's waived. Absolutely.
So then what are we doing here?
You want us to waive the waiver?
Yes. Absolutely. Because
Can you point us to a case that suggests that that's what we're going to do or should do, or that that's the law? Or are you just affirmatively asking us to make up something?
Yes.
Okay.
Oh, absolutely.
Okay.
Because if you don't do it now, it'll come back later, because it's ineffective assistance of appellate counsel not to have raised it before. And the reason that you haven't seen this before, we didn't have verdicts like this way back when. You wouldn't know what the jury was thinking, but here we know. They said there's no mitigation here, which obviously means they didn't pay attention to the judge, because the judge found 29 non-statutory mitigating factors. And so, you know, if you remember, the whole reason we have the death penalty, they set up this system where aggravating factors have to be established and mitigating factors for the purpose of narrowing the class and not being arbitrary. As this court is well aware, and you've heard numerous arguments that with aggravator creep and all that, we don't have that system anymore in this state. We just don't. You can't think of a way to kill somebody that you're not going to be death eligible anymore. So it has become arbitrary, and it's now even more arbitrary when the jury's even ignoring the judge's instructions. And at some point, this court has to address this
What
issue.
evidence do you have here that we should rebut the presumption that the jury, in fact, followed the judge's instructions and, you know, heard them, but decided to come out another way?
Well, it speaks for itself.
What speaks for itself? Help me, because I don't see it.
They found on the verdict form no mitigation has been proven.
And you're saying there's no way for a jury to have reasoned to that conclusion? It's impossible?
Yes.
Okay.
Absolutely.
And the basis for that is?
That the judge found 29
So
non-statutory mitigating
when the
factors.
jury was instructed, were they instructed that the judge had found that those mitigations were uncontroverted?
Say that again, Justice Lamarck, I'm sorry.
I'm too far back. I'm sorry. When the jury considered the verdict, when they deliberated, did they know that all those mitigators had been found to be uncontroverted, and were they told you have to assume they're true? Something like that? I mean,
No, I don't believe they were instructed
so
that.
how does the jury know that the judge found them to be uncontroverted?
How do we know what the jury was thinking?
Right.
We know what they were thinking. They rejected the fact that any mitigation existed on its face by their verdict, which means they didn't follow the instruction, because the judge said you must find mitigation if it exists in
Well,
any way.
let me ask you this, counsel. Does the statute require that they make a specific findings of mitigation? I know the statute requires that they consider mitigation, and they've got to make determinations on the aggravators, and then they've got to make the bottom line determination, recommendation. But there's nothing in the statute that requires that there be determinations individually about the aggravators, is there?
No, sir.
I mean, and the reality is that this verdict form and these interrogatories, the court had kind of gone off and done this, and then we figured out later that wasn't really smart, and we took a different tack. So this is in an area here where it's detached to a certain extent from the statute. So it doesn't have to be viewed in the context of all that.
Well, it's viewed this way. If you look at the two Georgia cases, Gregg and Furman, and then Lockett versus Ohio, if you put those three cases together, that's the support for this. To have properly constitutional death penalty sentence, these things are required. Mitigation you're very familiar with Lockett. It's wide open as to what you can present in mitigation because of Lockett, and the standard of evidence is different for mitigation evidence. So it's inexplicable for why the jury didn't find on the verdict form that some mitigation evidence was presented. It's inexplicable. So the only conclusion you can come to is that they didn't follow the judge's instructions. And as you know, we get heightened due process in capital litigation. This is not a contract dispute. This is where someone's life is on the line. So it's a different scrutiny. And you guys can address this now, or you could address it later.
Well, we've got another case today that raises the same issue.
The one that follows.
But actually, it raises it in the context where it maybe isn't barred in the way it would be here.
No, I understand your statements about waiver, and it's true. It's absolutely true. And I just submit that judicial economy, you can deal with it now and tell the state and all the judges with these verdict forms that it seems to be a mistake, to paraphrase you, Justice Kennedy, that we won't have this anymore. So that's why I raised it. I was totally, in all candor, knew that it's something that you may not want to address today, but I thought this court should be made aware of it, and you can choose to do as you wish.
What about your second issue?
Yeah, the second issue, the medical examiner in Jacksonville had dementia. At what point, evidentially, we don't know, but she certainly did. And they made a claim procedurally during the course of these interactions in 2018, 2019, that it's newly discovered evidence because they got, because of HIPAA, it's not easy to get people's medical stuff. Oh, they got it, and it showed that she did have dementia. I think she actually passed from dementia eventually. And their argument is, well, if she had dementia, she's a disqualified witness under the evidence code 990.603. She'd be a disqualified witness. So how are you going to, it's not a case where you can get a substitute ME and look at her notes. If she had dementia, her notes aren't good either.
Let me ask you this, two parts about this. When this was dealt with below, an order was entered.
Mm-hmm. Yes, sir.
Why would I think that's anything other than a final order?
I think you can take that position.
That it's a final order?
Yes.
Well, if it's a final order, the appeal was not timely.
That's correct. Ineffective assistance also. Absolutely. But us as coming before this court, we can't ignore ineffective assistance. And there's been a lot of change in that.
Well, let me ask you the second part. The second thing I want to ask you about this.
Yeah.
How in any way does the supposed mental-ish problems of the medical examiner have any significance here when the medical examiner's testimony was so dramatically inconsequential?
Well, very easy. A great question. And the reason is...
I try to ask good questions.
Yes, Your Honor. The reason is because we don't know, because there's no evidentiary hearing. That's what we're fighting about here.
We do know. We know what she testified to, which was like the nothing. I mean, the tragic circumstances here
Yes.
of this incineration, but the result of that was that she gave what she testified to was not material. And so the idea that we don't know, that just seems to me to be fanciful, because we know what she testified to. That's on the record.
Oh, absolutely, but with an evidentiary hearing, you could be able to flush it out absolutely. And that's we're not saying
What's the fact at issue in that evidentiary hearing? What are we taking testimony on to determine whether or not it's true?
whether or not she was so impaired that what she did would not justify her testimony.
Tell you what, let's assume she was impaired. Now what?
Well, under the evidence code, she'd be disqualified as a witness.
Great, we disqualify her. Now what?
Well, how do you have a cause of death?
I still have a deceased 10-month-old baby in a garbage bag and an incinerated girlfriend, right?
Well, that's what that 15-year-old testified to.
No, I have those bodies, don't I?
No, sir. They never discovered the body of the child.
Okay, I have the body of, you're right, but I have the body of the girlfriend.
Yes.
And I have the testimony about the baby.
Based on what Mr. Griffin said about what happened. And so, like
Again,
I said,
the testimony as to the baby is unchanged by the exclusion of the ME, right? Mm-hmm. Okay. So it seems to me like, having worked through the logic and excluded the witness, we're still in exactly the same place, aren't we?
well, yeah, you could take that position, absolutely. But in cases like
What's
this,
the other position?
the other position is just have an evidentiary hearing to have full due process.
I think you're fighting the logic that you just walked into. I mean, I think you should concede the point here, which is that the hearing that you advocate for at the end of the day has no impact at all on the outcome of this case.
Yeah, I could see why you could say that, and quite frankly, this is a very challenging appeal to do.
No, and we appreciate that you're doing it. I just wish it were about the Spencer hearing.
Well, the Spencer hearing had the defendant's mother, his wife, and his two daughters testify. That's it. And they just said, said nice things about him. I mean, that's it. There was nothing else presented. I don't know what argument I could make to this court based on that presentation, honestly. It didn't make it less mitigating or anything else. And it should be pointed out, in a new penalty phase, the aggravation got more severe. They found hack in the second penalty phase where they didn't in the first. And I think that's significant. It's as you know, CCP and hack murders are weightier aggravators than any others. So the first penalty phase, they didn't find hack. So
Well, I mean, it's, if you want to argue, but you're not arguing about that, because it's hard to argue about it given the facts here, correct?
yes,
Putting
well,
a baby in a bag and disposing of it in a dumpster, and then incinerating a woman, the mother of the child. That kind of sounds like hack to me.
I will concede it is hack, especially with the child victim. Absolutely. And so, anyway,
Of course, that's what.
Let me ask you, I mean, I guess the issue that we're here on pretty much is that we sent the case back on the question of Spencer hearing, because the trial judge at the time, right before the Spencer hearing was supposed to commence, the prosecutor informed the judge that, hey, we had this new motion from the defendant, and he wants to proceed on his own. So the prosecutor's kind of hinting to the judge, before you proceed to anything else, you need to take care of this. And the judge kind of just waved them off and proceeded to something else, went ahead and sentenced them to death, and then, you want to do that Spencer hearing now. So obviously there was an issue there concerning the defendant's right to proceed pro se if he wanted to.
Yes.
So we sent it back for that. The only reason we sent it back is for the trial judge to conduct that proper Spencer hearing and
Yes.
and to see what the defendant is. As it turned out, when it went back, now the guy wants a lawyer. So he changed his mind again.
Yes.
So, aren't we done? Given the objective of what we
Yes.
had this case go back for?
You can certainly take that position, Justice LaVarga, absolutely. Absolutely.
Okay.
And with that, I will finish up and allow my opposing counsel to go forward. Thank you very much.
Thank you.
May it please the Court, Lisa Marie Lerner with the Attorney General's Office for the state. As this Court knows, it issued a very narrow remand only on the Spencer hearing. This is not a second appeal of the second penalty phase trial. And if the Court has no questions, I will rest on my brief.
I have a question.
Yes.
So since we've already wasted time with this remand that should never have happened in the first place, is there anything that we can do in our disposition of this that would address the questions that he says are going to have to be addressed in later proceedings? If we decide to overlook the fact that these issues that he's raised aren't really properly in front of us right now?
The evidentiary hearing issue, the Court, in an act of charity, took it on the merits and found that he failed to meet either of the Jones prongs for newly discovered evidence. And his reasoning was solid given the situation and the facts of this case. So that issue is settled as far as the state is concerned. In terms of the jury, jurors have a very limited duty in terms of mitigation. It's not the same as if they were aggravators. They do not have to find them beyond reasonable doubt. It is up to the individual juror to make what the Supreme Court has called a value call on whether a set of facts is mitigating or not. They may believe the facts, but don't find them mitigating. And we know that the jury followed the instructions in this case because we have that jury form, verdict form, where they go through each mitigator individually and tally how many jurors voted yes to find it mitigating and how many jurors voted no. And on a number of the mitigators, some jurors found it mitigating. So we know that the jurors followed the instructions and individually analyzed the mitigators. However, the jury as a whole found that the mitigators were not established, nor were they sufficient to outweigh the very weighty aggravators. And the verdict form shows that. Further, under our statute and Supreme Court law, the trial court has no obligation to adopt the jury's assessment of the mitigators. It has an independent duty to go and evaluate. The court is the sentencing body, not the jury in the state of Florida. So the court individually evaluated the mitigators and in its role found 25 mitigators, non-statutory, that it gave weight and 4 that it gave no weight.
So in terms of addressing that in this opinion, would your position be that regardless of the procedural issues waiver and exceeding the scope of remand, that there wouldn't be a need to address it in this opinion because counsel wouldn't be ineffective for failing to raise a meritless issue regardless?
Yes. And there's no ineffective assistance of appellate counsel because it's a non-meritorious issue.
And I
with
can't
that-
remember, did the form distinguish between whether the underlying facts were proven versus assuming the facts are proven, whether it's quote-unquote mitigating or not?
No. What they did, and interesting, in the 2020 Record on Appeal, the verdict form is not in there. It is only in there as an exhibit to the motion for new trial, and it starts at page 1319. But it only goes through saying, evidence was presented on this, do you vote yes or no? And then they go through
Yes
and
or no as to what?
whether or not it's mitigating.
Okay, so in that
Not-
sense, so really then, I mean, that just shows that supports the idea that maybe the jury, so the inconsistency, it's one thing to sort of disagree as to whether something factually was proven, you know, did someone have a bad childhood or whatever, versus do I consider that mitigating? The jury obviously has discretion, regardless of what facts are put in front of them, whether they view that as mitigating or not, right?
Yes.
And
Yeah.
so the form isn't, so it's not as if we can infer from the form that they just literally sort of arbitrarily disregarded the existence of, you know, objective things in reality that happened, as opposed to whatever kind of, you know, sort of judgment-wise, what significance they give to that.
Well, the state maintains that by looking at this form and seeing when the court polled the jury when it gave its recommendation, the jury obviously considered it because some of the jurors, and it was not always the same number. It
Well,
would
I mean,
be-
so the form establishes that they did not ignore the instructions.
Correct.
They may
And-
not have considered it in the way that the defense wanted it to be considered, but that's within their province.
Yes, and it shows that they discussed it, because some people said yes on this and no on that, and it shows that the jury went through each one individually and discussed it, evaluated it, considered it, and then ultimately weighed them against the aggravators, and unanimously found that they did not outweigh the aggravation.
Right, and
then-
constitutionally, a defendant, all that you're entitled to is to be able to present what the defendant thinks is mitigating and to have that fairly considered.
Correct.
Right? Okay.
And with that, the court, the state asks you to affirm. Thank you.
Justice Kennedy, I disagree respectfully with you on the issue of whether or not the mitigation was handled properly in this case. The fact they discussed it or did it is immaterial as far as I'm concerned. If they find none existed when it clearly did, they didn't understand what they were supposed to do. That's our position on that. And then secondly...
Well, I think there's some confusion in the way these interrogatories were structured. And
Agreed.
I do not question that, and that ultimately the court decided that, and because we changed it.
Yes, sir.
But the idea, the kind of the premise for your argument is that they really didn't consider mitigation. And that is absolutely contradicted by what we've just been talking about.
Well, I don't want to parse words, but they can consider all they want. And we're not claiming they didn't consider it. We're saying they didn't follow the law. That's what he didn't do. The jury didn't follow the law by finding mitigation that existed. That's our position. And then finally, on the second point, the judge was wrong to say that the evidence was easily discoverable. It wasn't. We have a HIPAA law. It was not easily discoverable at the time. And so and I'm just addressing the AG's comments in that regard. That isn't true. There was no way they could have known about her medical diagnosis. So it is newly discovered evidence. With that, I conclude.